Hello, everybody. This is Advocate Lucinda, your empowerment lawyer. Mr. and Miss Pro Se litigant. When you file a lawsuit, it is critical that you conduct discovery. You cannot afford not to conduct discovery on some level. And there are many tools through which you can conduct discovery. After the plaintiff files the complaint, there will be a pre-discovery process where the plaintiff and defense counsel will meet to discuss the discovery plan. This is called the 26F conference. And that's what we're going to talk about today. How to prepare for the 26F conference. And I want to give you some tips. So let's get started. So what is the 26F conference? In the Rule 26F conference, plaintiff and defendants counsel meet and confer on a plan for the pending litigation. It serves as a guideline for the parties to follow, and it helps to keep the parties and the litigation on track. You can read this at Federal Rules of Civil Procedure 26. The Rule 26 provision regarding the timing of the discovery conference requires that the parties must confer as soon as practicable, and in any event, at least 21 days before a scheduling conference is to be held or a scheduling order is due under Rule 16B. 16B refers to when the plaintiff and the defendant, after having met and conferred, will meet with the judge. And the judge will go over what came out of the plaintiff's and the defendant's meeting. And we'll talk about that a little more. Rule 16B, except in categories of action exempted by local rule, the district judge or a magistrate judge, when authorized by local rules, so you want to look at your local rules, must issue a scheduling order. 1, after receiving the plaintiff's and the defendant's report under their Rule 26F meeting when they met and conferred, or after consulting with the party's attorney and any unrepresented parties at a scheduling conference. Of course, this is after the judge has consulted with the party's attorneys. My tip 1, know the facts in your case very well. I cannot stress that enough. And if you've watched any of my videos, you know I put emphasis on knowing your facts. In addition, you should know every defendant and understand each allegation that you've alleged against the defendant or defendants. Understand the prima facie elements for each cause of action brought against the defendant or defendants. This is important because it will help you to know what questions to propound in your discovery requests. Tip 2, know what topics should be covered at the 26F conference. Certain items must be covered at the 26F conference. I am providing you with a checklist of the topics that are discussed at the conference so that you can be prepared when you and opposing counsel meet and confer. A link for the checklist will be located in the description page of this video. Tip 3, prepare a proposed report and scheduling order. You will be better prepared when you meet and confer with opposing counsel at the 26th conference. This is a practice for you. The final report and order will be completed by you and defendant's counsel. It will then be submitted to the judge for approval. I am providing you with a model report and order that you can tailor to your case. A link for the document will be located in the description page of this video. And you always want to look at your local rules. And usually you can find a template for your jurisdiction concerning what is included in this report and scheduling order for your local jurisdiction. Tip 4, be ready to work with opposing counsel. Work with opposing counsel at the 26F conference and beyond. Don't let emotions and your fire, and please keep your fire, but don't let it get in the way of civility and cooperation. Notwithstanding how opposing counsel may conduct himself or herself, be the bigger person in the room. Report their behavior if you have to, if it gets to that point, but keep it cordial. Stay focused. All right, that was short and sweet. You can do this. Until next time, I'm Advocate Lucinda, your empowerment lawyer.